I want to raise an issue that hasn't been discussed. All of you very comfortably asserted that this was constitutional, that the ECRA was constitutional. Mr. Mueller, I think you used the term well within constitutional bounds. I'm worried about the implications of the so-called independent legislature theory. And the theory basically holds that there's a difference, there's a subtle difference between the election clause in Article 1 and the election clause in Article 2. Article 1 says legislatures and the state shall set election rules, but then, semicolon, Congress may amend or override those rules. In the election clause for the president, it talks about the state shall select electors in a manner the legislature shall direct. There's no provision for congressional express provision as there is in Article 1. And there are those who assert, and apparently we now have 3 justices, Thomas, Alito, and Gorsuch, who appear to accept this independent legislature theory that nothing can override and they can do anything they want whenever they want. Mr. Bauer, let me start with you, since you're a graduate of the same law school that I am. I'll give you that. I'll give you the privilege of beginning. What do you think of this theory, and is this a concern in the context of what we're discussing here today?
No, I don't believe it is. There's been a lot of different meanings assigned to the term independent state legislative doctrine, but I think one thing is very clear, which is whatever state legislatures may do in the manner of appointing electors, they cannot violate other constitutional provisions. They are still faced with the requirement that their actions be consistent with the Due Process and Equal Protection Clause, with the right to vote under the First Amendment. So there are constraints, and I don't think in the most extreme form that somebody might suggest that one might understand independent state legislature doctrine, I don't think that would be an accurate statement of what is available to state legislatures under our Constitution.
Mr. Mueller, your thoughts?
Yeah, so Congress has the power to choose or to define the time of choosing electors. And so one of the really important things this bill does is by eliminating the fail to make a choice provision and saying all of the rules have to be in place as of election day, then it puts in place that if you're going to hold a popular election, we're going to follow those rules. And there's no opportunity to show up later and do something else. And so while there might be in the most aggrandized theory of the independent state legislature to say the legislature can do whatever it wants, perhaps that's true, but it has to do it on the first Tuesday after the first Monday in November, and it has to have laws in place well before that election.
So the power in the Congress to set the date is a constraint on the legislature acting retroactively.
Correct.
That's reassuring. Mr. Gore, do you agree?
I do agree that the independent state legislature doctrine is not implicated by the Reform Act. And I agree with Professor Mueller's reasons for that. And I'll just add that this provision that clarifies that the governing law for presidential elections is state law enacted by state legislatures prior to election day further allays any concerns there might be under that doctrine.
Do you feel that the Electoral Reform Act adequately deals with the rogue governor problem of a governor who basically refuses to certify? Because we've got people running for governor who are saying, I wouldn't have certified in 2020. Is that addressed in these bills? That was something we tried to address in our draft bill. Mr. Gore?
Existing law already contains mechanisms to address the scenario of a governor failing to certify a slate of electors or certifying the incorrect slate of electors. As I mentioned before, state laws have robust procedures for adjudicating election disputes, including that kind of dispute. The Reform Act doesn't displace any of that. It preserves all of those processes and procedures. And to the
extent, you think the current procedures are adequate and the Reform Act doesn't need to address this subject?
I think the Reform Act does not need to address the subject because there are legal remedies in place at the state level, and to the extent there are also federal constitutional or statutory challenges that could be brought, the Reform Act also leaves those mechanisms in place.
Mr. Bauer, do you agree with that conclusion that the rogue governor issue is adequately dealt with in existing law, doesn't need to be addressed in the Reform Act?
Well, certainly it is addressed under existing law. I think there are remedies available under existing law, but I would also point out again that it's very effectively addressed as a procedural matter through the expedited judicial review provisions that apply to the lawsuits we discussed previously that presidential and vice presidential candidates can bring to challenge a a certificate that a state executive or state legislature wrongfully puts forward is the correct one. So it does touch on that, certainly, by expediting relief available under existing law.
Mr. Mueller, one final question. We've got the voting period potentially modified by, quote, extraordinary and catastrophic events. Is that an adequate definition? Do you feel that provides reasonable guidance that can be litigated, or does it create an opening and an ambiguity?
So in my judgment, first we have to think about the status quo, which right now is that if there's failed to make an election, the legislature can do whatever it wants, essentially. So by abolishing that and replacing it with this provision is a dramatic improvement. And the only remedy that can happen is a modification of the voting period, not suspending or delaying the election.
But what if the legislature says, we had widespread fraud in the city of Philadelphia, that's an extraordinary event, and we have to throw out the result?
Right, so extraordinary and catastrophic, I think, are understood not to include allegations of voter fraud, and as an independent constraint of federal law, I think it would prohibit states from enacting laws like that. States already have emergency election laws on the books. To my knowledge, none of them define voter fraud as a basis for an emergency invocation of executive authority. So it offers an independent federal constraint while relying on the stable existing state mechanisms for handling catastrophes and emergencies in elections.
Mr. Gore, you satisfied with extraordinary and catastrophic?
I think that is another issue that is best left to the states to decide again before Election Day for the reasons that Professor Mueller has laid out.
Thank you. Thank you, Madam Chair.
Thank you, Senator Padilla. Senator Cruz is willing to have you go next, even though he's next, and appreciate that. Thank you, Senator Padilla.